we want, okay. For our announcements for next month, we have actually, Brad has invited the Murray Police to talk about, oh, dang it, I keep calling it rapid shooter. What is that called, Kent?
Active shooter?
Active shooter, yes. Active shooter. And they will help us find ways, if we are in that incident, how to protect ourselves. I just want to remind you of our Facebook page, and since this is being recorded, you can access it or share it with your friends later on. Those sisters that are in the audience, I want to remind you of our upcoming quilting night that will be on June 24th, Thursday, June 24th. Please come and participate. I've invited Kent Snider, attorney at law. He is in our ward, 16th Ward. He's a wonderful gospel doctrine teacher, and you've heard him in state conference, so you'll know what a great speaker he is. He has multiple hats that he wears, and I was going to read the bio, and I can't get it on my phone, but he graduated in respiratory therapy. He's been a former cop. He is probably a lot more. He's in estate planning, and Kent, I'm just cutting you short. There's so much I could say.
Don't forget the nail salon, okay?
Oh yeah, that's true. He owned a nail salon at one time. So Kent can take our breath away by telling us how important it is to prepare for our future. And since he's a respiratory therapist, he can restore it by giving us skills on estate planning. So I'm going to turn the time over to you, Kent. Thank you.
Now, I only mentioned the nail salon because we were having dinner the other night with a few of the couples in the ward, and my wife mentioned that I had a nail salon once upon a time, and Bonnie went, "What? What haven't you done?" So that's the only reason I mentioned it. Please, I have got everyone up here on my screen. So if you have questions, please unmute yourself and just feel free to ask questions. Okay. Don't worry about interrupting. In fact, I'm going to try to leave a little bit of time, hopefully at the end, that we can do this. When I talk about estate planning, there's several of us are estate planners. There's quite a few really, really good estate planning attorneys here in Salt Lake. I prefer to avoid estate planning and like to talk about life planning because, well, estate planning is about money. Life planning is about being prepared. And as we know in the Doctrine and Covenants, section 38, if you are prepared, you shall not fear. I read through section 38 again tonight, and I thought to myself, well, how absolutely appropriate it is for us to be prepared now. Bonnie, can you hear me okay? Okay, because I can't hear anybody because they've all muted themselves. So what I want to talk about tonight is comparing an estate plan and essential estate planning to essential physical preparedness. So for example, if I were talking to you about a 72-hour kit, 72-hour kit is a bare minimum. What I need to do to take care of me and my family for 3 days until help can come. That can go anywhere from 72 hours up to a 1-year supply. I wish this was my food supply. It's not. It's much greater than anything I will ever see. But we're going to compare estate planning to the bare minimums of what we need. For example, in a 72-hour kit, did everyone, maybe by the raise of hands, I sent to Bonnie and to President Baker a few handouts, a little booklet. I sent a living will. I sent a copy of a power of attorney that they're just free that you can print off and fill out on your own. We're going to talk about those, but please, I think Bonnie was going to list it on the Facebook page.
Yes, that's where it was supposed to be listed. If it's not now, it will be.
Okay, well, and if it's not there, I'm going to give you my webpage. It's actually sniderlaw.org. And if you click on that, there is a resource page where you can literally download those for free. So if you want to at least get your 72-hour estate planning kit in effect, I've got those online right now. So if we were going to, like I said, compare a 72-hour kit with an estate plan, the bare minimum everyone needs, not just people who are married, not just people who are over 45. I recently, as a respiratory therapist, I worked in the hospitals for way too many years, almost 30, and I had to withdraw care on several people, including some very young people. Everyone needs a living will. Everyone should have a power of attorney. And everyone, if you own property, and we're going to walk you through what you need to do to protect your property from exploitation and fraud. And I'll show you right where to get online and do that with the Salt Lake County Recorder's Office here in just a second. So this is a Utah Advanced Healthcare Directive. It's the standard form. You can download this from my webpage or from the Facebook page. We're going to talk just briefly about how to fill one out, but everyone needs, as a bare minimum, an advanced healthcare directive. This is not a will. It doesn't tell what happens to your property. It is what you want to happen to you should you not be able to speak. And for every time I talk to people about this, they go, well, wait a second, if I fill this out, what happens if I change my mind? And that's the very essence of an advanced healthcare directive or a living will, is you can change your mind. You fill it out, you can speak on your behalf, you can continue to express what you want, you can change your mind, but in the event that you are no longer able to express yourself, you're on a ventilator, you're intubated, you've had a stroke, you're aphasic and you're no longer able to speak, it allows you to be able to say what you want to happen. So it's very simple. You fill in your information here. You put your agent. The agent is the person you want to make those decisions for you right here. You turn around and you put your alternate agent right here. That's the person who is the backup. And then you go on, there's only 4 pages and it's all fill in the blanket initials. And you, even if you want, for example, if you want your spouse or one of your children or your trusted friend to be able to talk to your medical providers, you want them to be able to access your medical records, even when you're able to talk to yourself. So those of us who are getting a little older, which is a lot of us, if you want one of your children to be able to talk to your doctor, be able to check in on you, make sure that they can access your medical records, you fill it out right here. If you want to designate someone to be your guardian or conservator, then you check this little yes here. If you want, organ donation, participate in research, but then on the 3rd page, you can go in and say, well, I want my agent to decide for me. You're done. That's it. Or if you want to prolong your life forever and do everything you can, I want all heroic measures and I have to do that, then you would check option 2. Or if you want to say, for example, my mother, when she filled out her living will, she said, I can be on a ventilator for 20 days or a life support for 20 days, but I don't want dialysis, or I don't want, if I've had a stroke and I'm not going to be able to communicate and I can't recover, I don't want you to start CPR. That's where you fill all those little, this section right here. You sign it and you have it witnessed. Now, this is the important thing. When I used to do this in the hospital, I used to joke and laugh about it, but there is a whole list of people who cannot witness your advanced healthcare directive. They can't be related to you by blood or marriage, which basically means no kids, no stepkids, no grandkids, no nieces, nephews. Takes everybody out of your family, okay? It takes out any of your not just your children, but your children's spouses, Anybody that would be entitled to receive something in your will, or anybody that's named in your trust, anyone who's a beneficiary, and then it gets really picky, anyone who is on a payable upon a death account, somebody that's on a joint account, somebody that's a joint tenant on your property, someone who is your healthcare provider. So when I used to fill these out at the hospital for people, they'd look at me and I go, well, who can witness this? And you literally have to find someone walking down the hall who was a stranger. But luckily for us, if we're filling this out at home, your minister, your friend, your neighbor, someone in the Relief Society president, Bonnie, she's great. Someone who is not related to you, they need to witness it. Everyone talks about, well, does it need to be notarized? No, it does not need to be notarized. Does it need two witnesses? You'll read some things that say there needs to be two witnesses. No, just one witness, and this you give to your doctors, okay? We're going to talk about powers of attorney just briefly. And again, if you have a question, unmute yourself and say Kent, and I'll be happy to address the question. There's two types of powers of an attorney. A power of attorney is you grant the authority that you have to manage or spend your money. You grant that authority to someone else. There are several different types of powers of attorney, but you'll always hear the word durable versus springing. Think of this, because we all are all of the age that you remember the Jack in the Box when you were a kid. This is a Jack in the Box. It's not a toy, it's just a box. And until you turn that crank and something happens, until it pops out of the box, or in this case, until it springs out of the box, it's nothing. That's the same as a power of attorney. If it is a springing power of attorney, something has to happen before it goes into effect. So as long as you're capable of expressing your desires, paying your own bills, handling your money, then you use a springing power of attorney. If you want someone to immediately take over and start making changes and having access to paying your bills or handling your property, then you have a general power of attorney. A general power of attorney, though, terminates upon incapacity. So if you become incapacitated, the power of attorney ceases to exist. A durable power of attorney continues even if you are incapacitated. So that's the power of attorney that I listed on on my webpage and also on the Facebook. It's a durable power of attorney. The springing power of attorney does not start until there's a triggering event. So for example, a triggering event has to be something like, I'm no longer able to manage my finances. My doctor believes that I need either help making decisions regarding my medical care, or, and we're going to have to talk about a couple of dangerous wordings that you want to avoid in your power of attorney. But it's more than just, I'm no longer capable of driving. It's more than just, well, my kids think that they need to help me make decisions regarding where I'm going to live. So we need to be very, very clear as to when that springing power of attorney goes into effect. And if it doesn't give a triggering event, it's durable, which means it goes into effect immediately. Language that says this power of attorney shall not be affected by disability of the principal, that's durable, it lasts. This power of attorney shall become effective upon the disability of the principal, that's a springing power of attorney. If a patient has a very limited capacity, or they're not capable of expressing what they want, or they do not understand, then they don't have the capacity to do a power of attorney. And I get calls from hospitals all the time. Can this patient do a power of attorney? If we wait that long, it's too late. So on my webpage and on the Facebook page, there is this statutory Utah power of attorney. If you fill in the language right here where it says effective date, this power of attorney is effective immediately unless you put something else here. Then you have to put in here instructions as to, if my primary care physician says that no longer am capable of making financial decisions, or I'm no longer capable of making decisions regarding my medical care, or I no longer have the capacity to understand and communicate appropriately. That's where you would put in something for a springing power of attorney. Your agent is the person you nominate. Your successor agent is the backup. And over here, you would just check or initial, don't check, initial everything you want them to do. So your personal property, stocks and bonds, real estate, everything you can either limit it or you can expand it. This, by the way, does have to be notarized. You can also nominate a conservator and a guardian, but it does have to be notarized. There are problems with powers of attorney. I see a lot of exploitation. In fact, we'll talk about that in just a second. So when you're picking an agent, and I see this happen a lot with my clients, you get the mom is all worried. Well, I've got this one child. I don't want them to feel left out. I'll let them be my medical power of attorney. That's a huge responsibility. You may want to consider giving the medical power of attorney to someone in the family who has a medical background. Someone's a nurse, someone has a pharmacist, someone has worked in the area of patient care. They understand the system. Or give that medical power of attorney to someone who goes with you that's nearby. Don't give it to the child who is over in New York or in Florida, because they're not here. Give it to the child or a trusted friend who's going to your doctor's appointments with you. Okay, now we also talked about, as a bare minimum, how you protect your property. You'll hear a lot online and a lot of warnings where people are getting online, they get access to your title, they create a false deed, they turn around and put the property, they record a deed transferring the property from you into someone else's name. And then that person can turn around and sell your home. Or worse, they can turn around and take a loan out on it. So they turn around, they list them as an owner on the property. You never get notice. You have no idea. They go out and they get a loan on the property. And unbeknownst to you, 3 years later, because you haven't paid on the loan, the mortgage company comes back and forecloses on your home and takes your house. And that happens a lot. So what you want to do is you want to go to the Salt Lake County Recorder's Office. This is the web page right here. But if you were to just go ahead and type in Salt Lake County Recorder, or you can type in this link, it will bring up the recorder's web page. Right here, it says Property Watch. This is a free service. You do not have to pay for it. When my wife and I were over at Bonnie and Ed's house, we set it up, and it takes less than 5 minutes to do this. You click on property search. It will bring up this web page right here. It will automatically take you to this page right here. And all you need to do is you need to fill in your address, your name. You need an email because the email is where they send notice. It will automatically populate your parcel number. So it creates the parcel number. You click apply and boom. If anyone makes any attempt to record anything on your property, you'll get an email notice. That's all you need to do. That's the bare minimum. Remember, this is 72-hour kit. So for a bare minimum, we want an advanced healthcare directive or a living will, a power of attorney, and you want to initiate the property watch. Okay, so now we're going to talk about what do you need for a 2-week supply? What's the next thing that I would recommend that you need to do? Okay, a will. We need to make specific changes in some bank accounts, so we'll talk about this. We need to be able to inform your spouse or your children in regards to your bills. You'll have no idea. I deal with one spouse passes away. They've been handling the bank accounts. The new spouse is frantic because they have no idea what bank accounts, where the checks are, what's outstanding, what's owed, how much money's in the bank. They know nothing. And if they're the only one that's been accessing that information, you may not even be able to get into the bank and don't put the information into your safety deposit box, because unless your spouse's name is on the safety deposit box, we need a court order to open it. So bare minimum, what we need to do is we need a will. But what if we don't? You notice I didn't say you needed a will as a 72-hour kit. What happens if I don't have a will? A lot of people will say, well, the state gets to decide what happens to your property. Well, the state's already decided what happens to your property. There are things that are called, just a second, let me get, yep, there we go. The Utah State Intestation Succession. So this is the law that determines what happens if you don't have a will. And the only reason I bring this up is because it happens a lot. We get mom and dad, they've been married for 60 years, dad passes away or mom passes away. The kids take care of mom. She ends up in an assisted living facility. She meets this very nice person his spouse has passed away also. They can become best friends and they get married. And they're in their 70s. If there is no will, half the property automatically goes to the new spouse. So if you're married, you have no prior spouse and you have no stepchildren, the entire estate goes to the other spouse. But if you do not have a will or a trust, you're married, you have a child from a previous marriage, one half of the property goes to your new spouse and the other half goes to your children. So the reason I bring this up is if you don't have a will, that's what will happen. So we come back here. We need a will. We need to inform your spouse in regards to the bills, bank accounts, passwords. Because if you don't have the passwords to the email accounts, you can't change them. You can't discontinue them. And what happens is someone can hack into them, access the information, and use it against you. Big, huge warning I want to talk to everybody about is a signator. Right down here, signature versus joint owner accounts. I get clients all the time that turn around and they say, well, I don't have to worry about it. I've put my kids on my accounts. And every hair on the back of my neck stands up and I go, wait a minute, what have you done? So I want to warn people because putting your children on the account may or may not be a good idea. If you have a jointly owned account, oh yeah, by the way, I've got my scary Jack in the Box here. Because they're scary. This is what can happen. If you have a jointly owned account with a child, okay, you trust your daughter, she's on your account, you jointly own it, she's a signator on it, everything's great, except she can use it for her own personal use. And I get my clients all the time, but that's okay, I trust my daughter. I don't worry about that. That's true. You trust your daughter. But what about a payable upon death account? We're going to talk about this in just a second. What about if your daughter gets divorced? Because if your daughter goes through a divorce proceeding, or if your daughter gets in a car accident and she's sued, your daughter is a joint owner on your account and they can come, either the spouse, the divorcing spouse, or the person who's suing your daughter, they can come, or the IRS, if your daughter owes back taxes, and come out and take your money out of your account. Payable upon death accounts. So you turn around and you say, well, when I die, I've already got my daughter's name on, or I got my son's name, payable upon death account, and they know they're going to use that money to take care of me. They're going to bury me with that money. They're going to pay my bills, and then what's left over, they're going to divide between the kids. Legally, they don't have to. Legally, that money belongs to that child. And I have more than once had to litigate the issue as to all of the other kids, all they got was what was out of the house, and the one daughter gets everything in the account and gets to use it for their own personal use. So be very careful with payable upon death or payable upon transfer accounts. They're great. They're a wonderful way to transfer property. But if what you want is to have that money used for your care or used for your burial expenses in your last expenses to get the house ready to sell, then you want to make not your child the POD, you want to make your trust the POD. So we talked about you got to be careful of rights of creditors to come after your property, divorces, and we bypass the other heirs. Okay. Jointly owned real estate. Oh, I've got it. I don't have to worry about probating anything. I put my kids on my deed so that it's recorded and they now are joint owners on the property. Well, you've now created the exact same problems. That's scary Jack in the Box. Joint tenancy is great. But they now own your house. So child versus a spouse, the rights of creditors, divorce, they can sell your property. I actually just had this last week where the daughter said, well, I don't have anyone to take care of mom anymore. I'm going to sell her house to my son for half its value. We're talking $300,000 less than what it was worth. I'm going to put mom in a nursing home. And mom's going, I don't want to go in a nursing home. And she's freaking out and she comes to me. We literally had to go get court order to stop her daughter from selling her house. So careful with jointly owned property, use a trust instead. And we'll talk about that in just a second. So we got a 3-month disaster. We have a 1-year supply. We're going to talk about what constitutes a 3-month disaster plan for estate planning. Bonnie, if I start running out of time, you raise your hand, okay?
You'll never run out of time.
I think I'm doing pretty good, but just keep me on. We still want to talk about property watch. You definitely want to protect your property, but let's talk about trusts. If you own a home, and you hear this all the time, there are attorneys in town that make a whole lot of money creating trusts for people that don't need trusts. But if you have real property, you own a home, and you want to be able to avoid probate, the real sure way to avoid probate is a trust. You still need a will. People tell me all the time, well, I have a trust, I don't need a will. A trust is like a cookie jar. And I forgot to put my Cookie Monster cookie jar on my PowerPoint. You're the Cookie Monster. Your cookies are your cookies. That's your stuff. Your house, your property, your cars, your money, that's your cookies. And those cookies are sitting on the plate in front of you. Those are your cookies. A trust is a cookie jar. We take those cookies, they're still your cookies, we put them in the trust, and we put a trustee in charge of that lid on the cookie jar. If you're the person who can still access that, pull the lid off, if you're the person that can reach in the cookie jar and get your cookies out, then it's a revocable trust and you're the trustee also. If someone else has to open the cookie jar lid and hand you the cookies, they're the trustee. And if you can't ask to open the cookie jar, if you cannot get access to the cookie jar, and it's up to the trustee what happens to your cookies, now the trust is irrevocable. So Bonnie and I were talking about this just today, actually, I think, and I apologize, there's a misspelled word in there, revocable. Why would you want a trust to be irrevocable? And this, I use irrevocable versus revocable trusts, and I call this my Barbie/Cabana Boy clause. The reason why is when one spouse passes away, the husband runs off and marries someone new, it's going to be Barbie. Or if the wife runs off and marries someone new, she's going to run off with a Cabana Boy. That can create problems with a trust. I always, you want to check if you have a trust. Most good trusts have this in there, that when the first spouse passes, the trust becomes so that the new spouse, the remaining spouse, the living spouse, can't marry someone new. They die, and then all of a sudden, that spouse and their kids get everything, and your children get nothing. We put an irrevocable clause in there to make sure that the children are protected from a subsequent marriage. People will say, well, why do I need a will if I have a trust? Because I have to have a pour over will, a will that will take what I didn't put in the trust And for example, I bought a new car, or if you're Ed, he bought a new set of golf clubs and then he passes away. He forgot to put the golf clubs in the trust. We create a pour over will that pours everything into the trust. And we talk about codicils. A codicil is a nice fancy way of giving your stuff away without having to change your will all the time. So the big difference with a disaster plan, we do an entire estate plan. We put everything together and you're protected. So lastly, what would you consider? Oh,
Can I stop you?
You bet.
Okay, so irrevocable trust means that it's locked in and the Ken doll replacement can't come and take all goods.
Correct.
Okay.
You can put all sorts of provisions in an irrevocable trust, but that's kind of what you do. If you have a trust and you haven't talked to your attorney about it for a while and you have some questions, call them up and ask them about it. Say, I would like to review. If you've remarried, if a spouse has died and you haven't remarried, you probably should look at your trust and talk to the attorney who drafted it and make sure that you update things. So for a more than a 3-month, or for a long 1 year or greater plan, we still do everything else. But what I want to recommend is a medical, not just, I want a medical power of attorney, but I would also recommend a prepaid funeral plan because it protects your children. It's basically a prepaid plan that when you pass away, all of your final expenses are taken care of. I would recommend if you've got a little bit of extra money and you're still in good shape, I would strongly recommend a long-term care insurance because I see an awful lot of people who are having to sell their homes and go through their entire estate to pay for their long-term care. They are pricey depending on your age, but normal long-term care plan is about $3,000 to $4,000, $5,000 a year. And if you do need long-term care and you need assisted living or memory care, it could be $5,000, $6,000, $8,000 per month. So you can see that would save an awful lot of money. I also recommend a life insurance policy, but I'm not a big fan of if you're over 70, you don't need a life insurance policy unless you've got everything else in place. Yeah, go ahead.
I have a question.
Go ahead, Curtis.
We have had, both my wife and I, a long-term care insurance from the time we started working. We were working. Now that premium that we have is a very good premium.
Yes, it should be.
And I've questioned that because we're not to the point where we're using any long-term insurance. I'm 79, she's 78. And I've had the question about that. What happens to that? The question you need to ask you, if we do not use it, what happens to the money?
Most likely, without looking at the policy, I don't know, but if it's truly a long-term care insurance, unless it's been converted into a whole life policy, or if it's written with a whole life policy, there's no cash value to it. It's insurance like car insurance.
Okay.
But you need to look at the policy to find out.
I think that's what we have, is the one that's just like the car insurance. When we're dead, when we don't use it, there's no money back.
Right. But I am everything is a case-by-case basis. But in what I see on a day-to-day basis, I would rather see someone with long-term care insurance than life insurance. Because should you need to go to an assisted living, or if you had a stroke and you needed to go to long-term care, your health insurance does not pay for it. And right now, there are places here in Salt Lake, several of them, that are costing $8,000 to $11,000 a month.
You have just answered the grunt of the questions I've had on that for a long time. Thank you, sir.
You're welcome. I mean, you're right at the point where you're probably, if you're going to need it, I wouldn't get rid of it.
Thank you.
But if you've got the assets and you've got the cash aside where you can pay for that care, then you won't need a long-term care insurance plan. But I'm a big fan of them, especially when especially if you can buy them now at age 55, 60. By the time you get to 75, they're too expensive. You can't afford them. 75, 80, they're too expensive. Okay, Bonnie, we're going to play a game now. We're going to play the game of life. Okay. Or what I affectionately call plan now or pay later. And these are actually real life cases that have come up in my career in the last 5 years. So I make this is the game of life in retirement. So you live alone. You were recently diagnosed with stage 4 lung cancer. Your doctor tells you you have less than a year to live. Your doctor advises you to get a pulsed form. Has anyone heard of a pulsed form? Has
No.
anyone? No? Okay. We're going to talk about why you need one, because I was a police officer for 6.5 years and I saw what happens if you don't. Okay. Your family attorney's already prepared. It's done everything. He's got a revocable family trust. You have a will. You have a medical and durable power of attorney. You have an advanced healthcare directive. Why do you need a pulsed form? A pulsed form is a physician order for life-sustaining treatment. I recently had a family member who had everything. She had cancer. She was what they called no code. She told everybody, I don't want any heroics. I'm dying. If I code at home, I don't want to have any kind of CPR. She gets short of breath. Okay. She starts having a hard time breathing. She gets a little scared. She dials 911 and they show up at the house, which is fine. That's perfect. But by the time they get there, the daughter is there also. She's got the advanced healthcare directive right in her hand. She's trying to stop the paramedics from coming in. And she's going, I have an advanced healthcare directive. She's no code. You're not supposed to start CPR on her. Okay. A pulsed form is a physician doctor order. It's the only thing that will stop a paramedic from cracking your chest. So the difference between a pulsed form and advanced healthcare directive, an advanced healthcare directive, remember I said can be changed or revoked at any time, which means if you dial 911 or if your kids call, they get scared. You're on hospice for Pete's sakes. And the kids are like, mom needs some help. She's having trouble. She's choking. She can't breathe. They dial 911. The advanced healthcare directive, although it will dictate what will happen when you get to the hospital, the paramedics have to start CPR on you. If you don't want them to do that, you need to meet with your doctor or your nurse practitioner and have them fill out a provider order for life-sustaining treatment, in addition to your advanced healthcare directive that we just talked about. Advanced healthcare directive is a living will. This is an order, and it's the only way you can stop people from, and I've done as a respiratory therapist, CPR on people unnecessarily because they did not have a pulsed form. You can download a pulsed form from my webpage if you want, but it has to be filled out between you and your doctor or you and your nurse practitioner. Okay, here we go. 9 years ago, before your spouse passed away, the two of you prepared a trust, a will, and a power of attorney. You were recently diagnosed with Alzheimer's. Your symptoms are mild, but your doctor wrote a note. Oh, sorry, there's a note. Wrote that he thinks you should no longer drive. The doctor's staff called your son, who is your financial power of attorney. That's it. He's your financial power of attorney. That's a big clue right there. They should never have called his son. This is a true story, happened. Your son just sold your car, just listed your house for sale so he can afford to care for you. He's moving you into a nursing home close to you in Idaho. Your son does not think you're capable of managing your finances or making good healthcare decisions. He took away your debit cards, your credit cards, and he will not let you spend any money at all unless you ask him. Can he do this? No. No. But he did. Okay. And we had mom who's living with a daughter going, I don't want to go live in a nursing home. I'm perfectly happy living with my daughter. He's going, nope, I'm your power of attorney. I get to decide. A power of attorney has to discuss these matters with you. By executing a power of attorney, you don't give up the right to express what you want. But you better be careful who you give it to. This son was the eldest, and he always took charge. He always did everything. And the reason why they put him in charge is because they thought if we don't, he will pitch a fit. And in reality, what happened is they gave him the authority to literally put his mom in a nursing home and sell her house. So choose your POA wisely. You are preserved to have capacity. You know, we can skip through this part here. This is actually a quote from Dr. Latches, who is the director of geriatrics in New York City. He says, 20 years from now, we will look back on our failure to protect the assets of vulnerable older adults with astonishment in much the same way we look back on allowing 8-year-olds to work in factories and doctors to sell their patients cigarettes, which both happened in the 40s and in the 30s. Let me give you some statistics. 70% of the US wealth is held by baby boomers and seniors. That's 70% of the US wealth. 22% of Americans over age 70 have mild cognitive impairment. 1 in every 3 seniors dies with symptoms of dementia. So the odds are we're all going to have some symptoms of dementia. Only 1 in 35 to 44 cases of financial abuse, okay, 4 to 2% are reported to Adult Protective Services. And between 2011 and 2016, there was a 74% increase in the number of cases reported to Adult Protective Services. So what does that tell us? It tells us that our seniors, 70% of the wealth, our seniors are being exploited and abused in this very similar way as I just described of that son and the power of attorney. In 2011, a Utah State study said that the state cost victim losses somewhere between 48 million and 210 million annually. And that's only in Utah. I recently had someone in my ward call me and tell me that they were exploited and taken advantage of by telephone fraud and lost $50,000.
Wow.
In New York City in 2016 alone, between 352 million to $1.5 billion a year is lost in elder fraud. And 2 out of 3 abusers are family members. So out of the top 3 types of people who abuse seniors, number 1 is that exploitation that I talked to you about from third parties. Number 2 and 3 are kids. You're 51 years old. She's single, has a good job, owns her own home, is independent, and has been estranged from the family for several years. The hospital just called. Your sister just had a major, quote, global cranial bleed, which means she had a massive stroke. She's 51. She's unresponsive. She may need to be intubated. You start digging through her finances to find out what's going on. You haven't been in her house for years. And you find that despite her being independent and having a very good job, she's in serious debt. Her home is in arrears. The car payments are several months behind. And everything's on the verge of foreclosure. What are you going to do? No advanced healthcare directive, no financial plan. The hospital needs somebody to make decisions, and there's nothing. What do you do? Curtis, you're the only one that's unmuted. What are you going to do?
Who are you talking to, me?
Yes.
What can you do? Can I answer that with the question? What can you do?
I'm glad you asked. Utah does have a statute that allows for you to get an emergency guardianship. It usually takes about 24 hours, but we can get you appointed as a guardian within about 24, depending on the day of the week and depending on which county you're in. Between 40 and 72 hours, we can get you appointed so that you can make decisions. That's why when you fill out that little healthcare directive we talked about, or your power of attorney, you want to make sure who you designate to make those decisions for you, so that if we do need a guardianship, you designate that. And that is on the form that you can do that. Okay. We talked about incapacity. Let's see. Legal capacity, these are all judge decisions, but if you can't manage your property because of mental illness, physical illness, or chronic use of drugs or alcohol, that qualifies for someone to get a conservatorship, which can help manage your money. I do a lot of work with the VA. I have reluctantly said that basically this is about everybody at the VA. I mean, if anyone who's had active duty, they have some type of a mental illness. Most of them have a chronic drug use. They have some type of a disability, but we qualify just about everyone to get someone as a either a VA payee or as a conservator with the VA. Incapacity for a guardianship. Guardianship is making decisions over the person's health. All we have to show is that even if they had technical assistance, they cannot continually provide for food, shelter, clothing, or make good healthy safety decisions, and they are unable to manage their own affairs. So I do probably 4 to 5 guardianships and conservatorships a month, because somebody did not make those plans ahead of time. Lastly, on that webpage and on the Facebook page is this booklet. It kind of goes through and explains everything we just talked about. Strongly encourage, as a bare minimum, everyone needs to at least have a advanced healthcare directive or a living will, power of attorney, and you really should have a will. I didn't mention this, but in Utah, people go, well, I can't afford an attorney. That's fine. In Utah, you can have what they call a holographic will or a self-proving will. So if you write the entire document out by hand in your handwriting and you sign it, that will constitute a self-proving holographic will. So you can actually go through and write out what you want. I want so-and-so to receive this. If I die, I want my house to be sold and divided. If you put those things in it and you write it out, I seriously, it looked like I did one just the other day, and we had to probate it, of course. But it looked like it had been written by a 3rd grader on that big, huge, broad lined paper that you used to have in the 3rd grade. And it was all written out, but she had done a very good job. We had a hard time reading her handwriting, but it qualified, and that's all you need for a will. Okay, any questions?
One question still occurs to me, Kent.
Yes, sir.
You have, say, a reverse mortgage on your home. I've lost you. Hang on a minute. What?
Am I still here?
You can see me, can't you?
Yeah, can you see me?
Yes. Can
Okay.
you see me? If you have a reverse mortgage on your home, how is that handled when the time comes for you to leave it for the last person in that home that's old enough, when that home is sold?
That's a great question, Curtis. And everyone, if you have a reverse mortgage, especially now in today's market, you probably got that reverse mortgage based on a value that's probably half of what it is now. And I get this a lot. People will go, well, I have a reverse mortgage. I have no equity. You may have hundreds of thousands of dollars of equity. Most reverse mortgages allow you, first of all, to live in the home until you cease to use it as your primary residence. So if one of you ends up having to go into long-term care, assisted living, that type of thing, as long as, and this is tricky, Curtis, if there's a spouse owns the house with his spouse or her spouse, and they're both on the reverse mortgage, that's great, because then we get to use either one of their lives. I recently had a case that involved, well, the husband's credit wasn't that great. So the wife got the reverse mortgage in her name, can be the other way around. Well, what ended up happening is the wife had a stroke. She went to the nursing home. She is no longer using the home as her primary residence. The husband's still living there, but he's not on the reverse mortgage. They made him sell the house because if they're not both on the mortgage, or if they're not both on the reverse mortgage, that creates a problem. As long as one of them is still living in the house and they're on the reverse mortgage, they can live there for the remainder of their life. Okay, if they both pass away, the reverse mortgage company normally will give you up to 1 year to sell the house, but you have to notify them within 60 days of the death. So you notify them, you tell them, we're getting the house ready for sale. This is who our real estate agent is. We're listing the house. As long as you keep updating them, they will let you sell the house. And you get to keep anything above and beyond the value of the reverse mortgage.
But now you're talking about someone else besides the last person on that reverse mortgage. If the last person dies, you have to have somebody to do that, don't you?
That's why we have at least a will where you name the personal representative to represent your estate. They can do that. Or if the home is in the trust and we've got a trust set up, the trustee can do that. And if you don't have a will and you don't have a trust, the laws of the state of Utah, we can still file a probate action claiming that the person died without a will, called intestacy. We still get somebody appointed to represent your estate. And there's a list of who has priority. And then they can contact the mortgage company and make arrangements to sell the house. Don't let it go back to the reverse mortgage company. You can lose hundreds of thousands of dollars.
Yeah, I've heard that. And that's why I wanted to ask you this very question.
Yeah, especially most reverse mortgages that I've seen recently was based on a valuation of a home of around $300,000. And there's not a home in our area anywhere that's even close to 300 grand. Most of the equity that I'm seeing is $200,000 to $300,000. Even on a marginal home, there's at least $80,000 to $100,000. So yeah, now the problem is you want to make sure your personal representative moves quickly, because the interest on that reverse mortgage tacks on quickly, and it can be up to almost $800 to $900 per month just interest. Sometimes up to $1,000 a month in interest. So every month it takes to sell that house and get it ready, you're losing $1,000 of estate money. But does that answer your question?
It certainly does.
Okay.
Open my eyes wide open.
Yeah. But they're great. They're a great way to pay for long-term care. They're a great way to pay for your retirement. And they are a great way to turn around and leave money to your kids. Any other questions?
Did you talk about trusts
Just briefly.
briefly?
Well-
Can you just talk about the benefits of having a family trust?
Okay, great. A family trust. The nice thing about a trust, the biggest advantage of a trust is I do not have to go to probate. I don't have to ask a judge to do anything. I don't have to pay the cost of going to probate. And people go, well, how much is probate? And people use the P word all the time. And attorneys say, well, if you don't have a trust, it will cost you thousands and thousands of dollars. If I have to go to probate and probate an estate without a trust, it's about $2,500, maybe more depending on who if there's an objection. If there's a trust, depending on the size of your state. Most people, we can do a trust between $1,200 and $1,500, $1,800 for a trust. Most of them are about $1,500 or less. And we don't have to go to, remember, the trust is the cookie jar. We don't have to probate anything. We don't have to ask for permission to do anything. Once you pass away, the trust, you're the trustee. For example, you and Ed are the trustees of your trust. You have total access. You can sell your house, you can rent your house, you can do whatever you want with your accounts. When you pass away, you want to make sure you name on all of your payable upon death accounts, your bank accounts, everything, name the trust as the beneficiary. You want to turn around and make sure on your life insurance policy, you name the trust as the beneficiary, because then everything pours into the trust, and your successor trustee, the backup trustee, can then divide it based on what you put in the writing. So that a trust is a huge benefit. And if you have real property, a trust is a great way to handle it. Or if you have money that you want divided without having to go to probate, it's a great way to be able to handle things.
So basically, everything you own in property, whatever, put it in through the trust.
But you have to put it in the trust. You actively have to. You change the ownership. For example, on your cars.
Oh yeah.
When you buy a car, the title of the car needs to say the Bonnie or the Ed and Bonnie Johnson Family Trust, or whatever it may be. You have to have the title put it in.
Okay.
If you buy a house, you need to quit claim the house to the trust and put it in the name of the trust. And when you do that, you don't do it on your own. You want to have at least someone who knows what they're doing, either someone in the title company or an attorney who knows how to specifically name the trust as the beneficiary, because I make a whole lot of money correcting bad deeds that never put property in the trust.
Wow. Okay.
And it's hard to find witnesses because they're already dead.
That's true.
Yeah. Any other questions? If you want to avoid probate and avoid trusts, you can do that by having name people on, for example, you have an IRA or you have an investment account and you want to turn around and put those assets and name certain kids as the beneficiaries when you pass away. It's a great way to avoid it. That's what my mom did. But if you have real property, the best thing I can tell you is do a trust. Some people do what they call sugar bowl deeds, is what the older people, my mom used to call it, my grandma called it a sugar bowl deed. And what happened is grandma would fill out the deed, sign it, have it notarized, and they would just keep it in the sugar bowl until grandma died, and then they'd go down and record it. They are called sleeping deeds. Utah allows you to do that, but it's a little tricky. It's much easier if you have it in a trust so that it automatically passes. And that way the trustee can sign the new deed, sell the property. Curtis, that's a great way to handle a reverse mortgage. Put the home in the trust, and then the trustee can handle it when you're gone. Did that answer your question, buddy?
Yes, excellent. It's kind of the catch-all of everything.
It is, and that's
fine,
why
too.
I like them. And it's
So
also,
Can that be,
go ahead, I'm
so
sorry.
can that be done after the fact? If you've already got the loan in place, can they then take and put the deed for the property in the name of the trust?
Yes, Arlene, in fact, they have to do it that way because people do this all the time. You put the home in the trust, but then you need to borrow money on it. You literally have to take the deed out of the trust, get a loan on it, and then put it back in the trust. So yeah, after you've got your mortgage or a reverse mortgage, you can always put the property in the trust. But you should have somebody who knows what they're doing. I mean, a quitclaim deed is a very easy document to draft, but if there is one comma or one mistake at all, it's kicked out. And people go years and years and years. In fact, I'm dealing with one now. 35 years ago, they thought the house was in the trust. They've even sold the house to someone else in the family. Never got in the trust. and we have to go back and correct the whole situation. So you have to make sure that if you're putting something in the trust, that it's done correctly. Any other questions?
And I've got a question.
Yes, sir.
Unfortunately, I'm in a situation where my mother and father put everything in a trust. I believe I have a copy of the trust and stuff, and she suffered with dementia and just passed away this week.
I'm sorry.
Previously.
Thank you. So now I'm trying to pick up the pieces and find out where everything stands. What is the best way for me to go about that?
If you want to find out if something's in the trust, we can do a real quick property search and find out if the house is in the trust or not. That takes less than 5 minutes.
Sure.
If there is a trust, there should be someone named as a successor trustee. There are, anytime you're dealing with someone who, and I see this a lot. In fact, I had a very, very close friend of mine who passed away at 92 or 93. And he said, you never know what kind of children you have until you get a little bit of money. Reluctantly, he said that often. But sometimes you don't know what kind of siblings you have until mom and dad are gone. And there's literally, I've got a case right now where the kids are squabbling over less than $80,000. There's 6 kids, and they had to break up the funeral. People had to be sent home by the police because of bad behavior. So it's much better if we have everything in writing and we put it what we want to happen, and we put the people who are in charge. But if mom passed away, you should be able to ask siblings, go through the personal records. If they had a family attorney, you can contact the attorney and let them know that they've passed away and maybe there was a trust. But the fastest way, Jeff, is we could do a property search in a matter of seconds and pull that up. I'm going to share my screen again just for a second here, because on the bottom, can you see that now?
Yes.
Okay, yeah, at the bottom of that, there's an email and there's a phone number that you can contact me if you need to. There's a better email address. I apologize, an old one. Kent@sniderlaw.org is the fastest email to get a hold of me.
Got it.
Kent@sniderlaw.org, not .com, but .org.
Got it.
Okay.
Thank you.
We can pull it up. We'll take just a minute.
Sure. And I'm pretty confident that the property is in the trust. It hasn't been updated for probably 30 years or so. So, and that was on my to-do list this year, but
It just took a higher level.
Yes. Anybody else?
I need to get the Facebook
Link?
yes.
Arlene, if you can either, Bonnie can give you the Facebook link, but if you want, you can go to my webpage. And in fact, I'll bring it up right now. It is just sniderlaw.org.
Okay.
Okay, I'm going to bring it up and share it with you. Because there's some free forms on there. Just a second. Okay, so when you bring up my webpage, it looks like, can you see that?
Hold on
Yes.
one second.
What am I sharing with you? Just a second.
Okay, this looks like the beginning of your,
Oh, you got the wrong one. I'm sorry. Let's go.
It says looking for a compassionate guardianship attorney.
Yeah, that's the webpage.
Yeah,
So, okay, so when you bring up my webpage, this is it right here. If you go over, do you see this little link right here where it says resources? Did I lose you, Arlene?
And I'm with you.
Okay, can you see the resources it highlights?
Yes.
If you click that, it will take you to, you can get a free advanced healthcare directive just by clicking it. It'll pop right up and you can download it.
Okay.
It's right there. It looks exactly like the one we just talked about.
Okay.
Okay. And I know you're going, why is an attorney giving away this stuff for free? Because I was a respiratory therapist for 30 years and I want people to be able to be taken care of. If you want a post form, there's one right here. If you need instructions for your doctor to fill it out, there's the instructions right here.
Mm-hmm.
The free power of attorney, if you click that, you can download that free power of attorney. It's right there. Okay.
Okay.
And yeah, there's a clinician's guardianship guide, but there's another one I'm popping in here in another day or two where I'm going to put in the document that I sent Bonnie. I can't remember the title of it, Bonnie. It's a new document I wrote. The planning ahead document.
Can I just tell you, we have a Facebook page. It's the Little Cottonwood Emergency Preparedness.
Also on YouTube.
And it's
Okay.
also on YouTube. So we were going to post those forms on there, but Kent, if he has it right there, it's worth, his site is fairly easy to get into too.
So, and this protecting yourself in uncertain times, it's a booklet. It's about 10 pages long, and it explains everything that we talked about tonight in short
Okay.
little bullet points and stuff like that. And that's on the web page, or not on my web page, but it will be in a day or two. But it is on the Facebook page.
Okay.
And if you want to make it real easy, you just send me an email and I'll send you a copy.
All right.
Okay, Kent@sniderlaw.org. If you just kick me a copy, I'll be happy to email you.
Okay.
Can I ask one question?
You can ask too.
Could you tell me again where I can go to do that property watch?
Oh, sure. We're going to have to back up here. Are you seeing the scary?
Yes.
Okay.
Mhm.
You know, I had to look all over for him. Okay, it's right here.
Okay.
So if you were to just type in your search engine, if it's Google or Bing or whomever, just type in Salt Lake County Recorder. This page will pop up.
Okay.
This is the web page if you want it. It's just slco.org/recorder.
Okay.
Okay, but if you just type in, it will bring it up. You click this button. It's right in the middle. It says Property Watch.
Okay.
And when you do, it will bring this page up right here, and you just fill in these lines. And everyone goes, well, I don't have the parcel number. It automatically populates. If you put in your address, it will give you the parcel number.
Okay. Thank you.
Okay. And if it doesn't do that, your parcel number is on your tax notice from the county recorder's office.
Okay. Thank you.
You're welcome. Oh, and where Jeff went, Mr. Moore, if you want to check to see if your parents' home was in the trust, it will also show up on that property notice too. Any other questions? I kind of went over, Bonnie. I'm sorry.
No, it was excellent. In fact, go ahead.
Steve, did you have a question?
Well, it's not Steve, it's Debbie, his wife.
Okay.
But thank you. This has been so informative and so well explained. I mean, I've attended a lot of different things, but you have done a great job. Thank you for your time. I'll be calling you.
This is not a solicitation. I just want to help people. So, yeah,
That was great.
happy to help you if we can answer your questions.
Are there any other questions? You'll probably think of them tonight at midnight, and Kent
If you
is a
do,
night owl.
if you do, well, we already had my phone number. You can give me a call. I'll get it back up here just a second. And this is my cell number, and I get clients all the time. Well, we don't want to wake you up. And I tell them all the time, if I don't want to be woke up, I won't pick up the phone. So it's okay. But that's my home. That's my cell number. And again, that's an email that I still use, but the fastest one is kent@sniderlaw.org. Kick me an answer at 3 a.m. I'll answer it. But I won't answer it at 9 a.m.
Thank you so much. That was, I mean, like I said, this is something that needs to be talked about over and over again. In fact, our estate attorney said your estate is a living, breathing program that you need to constantly go in and review, which this was a really good review for Ed and I, and I'm sure for everyone. You restored our, here your respiratory therapist, you restored our breath again, that we can, there is hope and that we can get our affairs in order. I've